Hello everyone. Welcome. Welcome to part third of the Constitution, which is fundamental rights, and we are going to read Article 13 in this one. In the previous video, we have already done Section 12. Now we are going to read Section 13. Section 13 says, I hope I am audible and visible to you, and my screen is being shared with you. Let me check it. Yes, it is, I guess. So, Article 13 states that subsection 1 all laws in force in the territory of India immediately before the commencement of this constitution insofar as they are inconsistent with the provisions of this part, shall to the extent of such inconsistency be void. And second subsection states, the state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause to the extent of the contravention be void. Part 3 says, in this article, unless the context otherwise requires, law includes any ordinance, order, bylaw, rule, regulation, notification, custom, or usage having in the territory of India the force of law. No, you have to remember this definition of law. Law includes any ordinance, order, bylaw, rule, regulation, notification, custom, or usage having in the territory of India the force of law. And this is an inclusive definition, as you can see. It's law includes. It's not comprehensive in nature. Secondly, it states that laws in force include laws passed or made by a legislature or other competent authority in the territory of India before the commencement of this constitution and not previously repealed, notwithstanding that any such law or any part thereof may not be then in operation either at all or in particular areas. And fourth subsection states that nothing in this article shall apply to any amendment of this constitution made under Article 368. Now we'll talk about it. What does it actually mean? So Article 13.1 deals with the pre-constitutional laws, whereas Article 13.2 deals with the post-constitutional laws, as you can see here. 13.1 states that the laws which were made before the commencement of constitution are void. And Article 13.2 states about the laws thereafter made after it. Okay. So pre-constitutional laws include Article 13.1, all pre-constitutional or existing laws, that is, which were in force immediately before the commencement of this constitution, shall be void to the extent to which they are inconsistent with the fundamental rights from the date of the commencement of the constitution. Article 13.1 is prospective in nature and does not give any retrospective effect. In post-constitutional laws, Article 13.2, it prohibits the state from making any law which contravenes or takes away or abridges the fundamental rights. If a state makes such a law, then it will be ultra vires and be void to the extent of such contravention. The term law in Article 13.3, here you can see, has been given a wider connotation so as to include the following. Number one, permanent laws enacted by laws or state legislature. Temporary laws like ordinance issued by president or the state governance. And statutory instruments in the nature of subordinate legislation, delegated legislation like order, bylaw, rule, regulation, notification, and fourthly, non-legislative sources of law, such that is, custom or usage having in the territory of India the force of law. Further, Article 13.4 declares that a constitutional amendment made under Article 368 is not a law within the meaning of Article 13 and therefore cannot be challenged for infringing the judicial rights. A judicial review refers to the power of judiciary to interpret the constitution and to declare any such law or order of the legislature and executive void if it finds them in conflict with the Part 3 of the Constitution of India. Article 13 provides for judicial review of all the legislation in India, that is past as well as future. And now here we'll understand about prosecution under pre-constitutional act. There is very important case, Keshav Madhav Menon versus State of Bombay, the year 1951. A person was being prosecuted under a law before the constitution came into force. After the constitution came into force, the law, that is section 18 of Press Emergency Powers Act, became void after Article 19(1)(a). It was contended that Article 13(1) could not apply to him as the offence had been committed before the enforcement of the constitution and therefore the proceedings against him should not be continued. The Supreme Court said that Article 13(1) does not make existing laws which are inconsistent with the fundamental rights void ab initio, but only renders such laws ineffectual and void with respect to the exercise of fundamental rights on and after the date of the commencement of the Constitution. It has no retrospective effect, and if therefore an act was done before the commencement of the new Constitution in contravention of the provisions of any law which was a valid law at the time of the commission of the act, a prosecution for such an act which was commenced before the Constitution came into force can be proceeded with, and the accused can be punished according to that law even after the commencement of the new Constitution. Doctrine of severability also derives from this article. The doctrine of severability states that when any provision of law is against the fundamental rights, but that provision can be separated from the rest of the statute, then only offending provision will be void and not the entire statute. It applies to both pre and post constitutional laws. In case the violating part of a statute is not severable from the rest of the statute, then the whole statute should be declared void. The basis of this doctrine lies in the expression to the extent of such inconsistency. To the extent of such inconsistency, as far as they are inconsistent, and to the extent of such inconsistency. Here you can read it in the last line of 13(1). Be void. This doctrine was applied by Supreme Court in A.K. Gopalan versus State of Madras, AIA 1950, and the court observed that Section 14 of Prevention of Detection Act 1915 was violating Article 14 of the Constitution, so it was declared void by the Supreme Court, but the other parts of the Act were separable and operative. In Kohoto, Hulan versus Chachilu and others, AIA 1993, also known as the defection case, Para 7 of the 10th schedule, which was first inserted by 52nd Constitutional Amendment Act 1985, was declared unconstitutional by Supreme Court because it had violated the provision under Article 368(2), subclause 2, and violated the basic feature of judicial review of the Constitution. However, the whole part was not unconstitutional, and the rest of the 10th schedule, excluding paragraph 7, was upheld by the Supreme Court as constitutional. Now, the doctrine of eclipse also applies from this article. It states that an existing law which is inconsistent and is in violation of fundamental rights shall be inoperative from the date of the commencement of the Constitution. The pre-existing laws will not become nullity rather than just remain unenforceable and eclipsed to the extent of such inconsistency with the fundamental rights. In the state of Bombay versus F. N. Valsara, AI 1951, the Supreme Court declared Section 13(b) of the Bombay Prohibition Act 1949 void because it violated Article 19(1)(f) of the Constitution. The court held that only the part of the statute that is violative of Part 3 is inoperative and not the whole statute. The court also held that in Bhikaji Narayan Thakara versus State of Madhya Pradesh, AI 1955, the CP and Bearer Motor Vehicles Amendment Act of 1947 was challenged for being violative of Article 19(1)(g), and the Supreme Court applied doctrine of eclipse, and the provisions of such act were made inoperative. However, in the 1951, by virtue of First Constitutional Amendment Act, Article 19(1)(g) was amended and eclipse was removed, rendering this law enforceable against citizens and non-citizens. According to the courts, the effect of amendment was to remove the shadow and to make the impugned act free from all blemish and infirmity. In the state of Gujarat versus Sri Ambika Mills, AIA 1974, it was held that post-constitutional laws should be void only to the extent of contravention. Therefore, the law would be void only against those persons whose fundamental rights are taken away or abridged, but would be perfectly valid as against those who have no fundamental rights. For example, certain fundamental rights like Article 19 are conferred only on citizens, and the law which is violative of Article 19 would be void as against citizens but would be perfectly valid as against non-citizens, as they are not entitled to the freedoms mentioned under Article 19. And Doctrine of Waiver. In Baseshwar Nath versus Commissioner of Income Tax, AI 1959, the Supreme Court held that fundamental rights cannot be waived under the Constitution of India. Personal laws, law within Article 13 or not. In the state of Bombay versus Narasu Appamali, AI 1952, the Chief Justice Chagla held that it is very clear pointer to the intention of the Constitution making body to exclude personal law from the purview of Article 13. The Constituent Assembly defining law in Article 13 have expressly and actively used only the expression custom or usage and have omitted personal laws. This above case ruled that personal laws doesn't seem to be in laws force under Article 13 of the Constitution as they are supported by religious precepts and customary practices, and the principles in Part 3 can't be applied to the personal laws. In Shara Bano and Others versus Union of India, AIA 2017, as per Rohinton Fali Nariman, you can see his YouTube videos, Justice and UU Lalit, who was the Chief Justice later on, and the Muslim Personal Law Shariat Application Act 1937, insofar as it seeks to recognize and enforce triple talaq, is within the meaning of the expression laws enforced in Article 13(1) and must be struck down as being void to the extent that it recognizes and enforces triple talaq, thereby the practice of talaq biddat or talaq was set aside. In Indian Young Lawyers Association versus the State of Kerala 2019, the latest recent judgment, Justice Chandrachud, D.Y. Chandrachud, who was not the Chief Justice then, observed that the definitional term law and laws enforced in Article 13, 3 and A, Article 13, subclause 3b, have an inclusive definition. As I've told you, it is an inclusive definition, not a comprehensive one. So more chances of being something new added are enjoined to it. Article 13(4) Constitutional Amendments. In Shankari Prasad Singh Dev versus Union of India, year 1951. This case relates to First Constitutional Amendment Act 1951. Remember this. First Constitutional Amendment Act came just after a year after the making of Constitution, which amended the fundamental rights. It was contended that it was not a valid law within the meaning of Article 13(2). The Supreme Court held that word law did not include the amendment done under Article 368. Rather, the word law must be taken to mean rules and regulation made in exercise of ordinary legislative power and not to the amendments in the Constitution made in exercise of constituent power. In Sajjan Singh versus the State of Rajasthan, AIR 1965, the court approved the view of Shankari Prasad and held that there is no limitation on the amending power of Parliament. In Golaknath versus the State of Punjab, AIA 1967, inclusion of a land. This is another case law, important one. In Golaknath versus the State of Punjab, AIA 1967, inclusion of a land reform legislation in 9th schedule by the 17th Constitutional Amendment Act 1964 was challenged as violative of fundamental rights. The Supreme Court overruled its earlier decision of Shankari Prasad and Sajjan Singh and held that fundamental rights are outside the amending powers of the Parliament. In order to dilute the Supreme Court decision in Golaknath case, the Parliament enacted the 24th Constitutional Amendment Act 1971, through which Clause 4 was added to Article 13, providing that nothing in this article shall apply to a constitutional amendment under Article 368. Clause 3 was added to Article 368 to provide that nothing in this Article 13 will apply to amendments made under Article 368. In Keshavananda Bharati versus State of Kerala, AI 1973, the Supreme Court by majority overruled the Golaknath's decision, which denied Parliament the power to amend fundamental rights of the citizens. The Supreme Court held that Parliament can amend any provision of the Constitution, including fundamental rights, but there are certain basic features of the Constitution which cannot be altered by an amendment under Article 368. You have to remember this, that Keshavanand Bharati lost the case, and Supreme Court held in favor of the government only, but in the state of Kerala, favor of state of Kerala. But it held that Parliament cannot overrule and amend anything, and it should abide by the basic features of the Constitution. It should abide by the basic features which will be laid down by the court later on. So yes, if you have, so these are the notes I am providing you, dictating you, because I believe these are the best notes available on this article, and yes, I hope you will like it. Thank you.